We thank you so much for watching Voices of the Bar, where the legal world speaks. And today we want to look at family law one, and we are going to discuss the bars to divorce. But we thank you for subscribing and sharing and liking our videos. We are also informing you that we actually run two channels. That is Voices of the Bar, where the legal world speaks. This is where we are right now. And also we run Law School Made Easy. So if you don't find a video on Law School Made Easy, it is possible that video is on Voices of the Bar. So we urge you to subscribe to both channels, Voices of the Bar and also Law School Made Easy. So today we want to straight go to bars to divorce under family law one, and we want to appreciate first the meaning of bars to divorce. When we say bars to divorce, we mean those things that court look at and denies divorce. That two married people come to court wanting to seek divorce, but court scrutinizes their evidence, looks at their petition, looks at everything the two have presented, but court decides to refuse to grant them divorce. Basically, that is what we mean by bars to divorce. I want to re-echo this topic. We are discussing the things that court look at and the court decides not to award divorce. Much as the parties come when they are willing to separate from each other, they are willing to dissolve their marriage permanently, but court looks at what they have presented in their petition and refuses to grant them the divorce. So there are two ways in which court can refuse to grant someone divorce. One, we call them absolute bars, and then two, we have the discretionary bars. What do we mean by absolute bars and discretionary bars? Under absolute bars, that when court finds out these things, court cannot proceed with awarding the divorce. And then discretionary, it is upon the court's discretion to look at the circumstance of events, and then court decides that we are giving these people a divorce or we are not giving them a divorce. Now, let's begin by discussing the absolute bars. Under the absolute bars, courts have looked at three categories under absolute bars, and one of them is collusion, the other one is condonation, and the other one is connivance. I want to re-echo them. Under absolute bar, we have two that we are going to look at. Number one is collusion, condonation, and connivance. Colleagues, I agree that some of you are literature students, you know a lot of English. Do not try and directly translate these words because you know a lot of English. There are other legal meanings attached to the word, the connotations of these words: condonation, collusion, and connivance. Please apply the legal reasoning as you discuss them. So I'll begin with collusion. Collusion under the law, or before I even go there, the absolute bars are provided for under Section 6. Section 6 of the Divorce Act is that clearly explains the absolute bars. Now, when we begin to discuss collusion, this is when the two married people fabricate evidence with the sole intention of getting a divorce. These two agree. It is even possible whatever they have done is actually true, it has happened, but their intention is to get divorce. It is settled law that you cannot come to court with the fabrication of evidence. When you come to lie to court and you get what you want, you cannot actually benefit from a crime. Already fabricating evidence is a crime. So nobody under the law, under contract law, nobody can benefit from a crime. If you remember your contract law, that case of Royal Ambulance, where a man killed himself because he had money under the insurance and he wanted his family to benefit from that money. So court ruled that you cannot benefit from your own crime. So these two fabricate evidence, produce evidence. They come into agreement to produce evidence such that court awards them a divorce. Courts cannot do such a mistake. And courts, therefore, that is what we call bars for divorce under collusion. That you will not be granted that divorce simply because there was collusion. You collided. You agreed with your spouse to come and secure a divorce. Probably you are tired of each other, but things you have done, you are doing them because you want to have a divorce. Remember, under our laws, divorce is the last option. That's why when we begin actually to discuss the orders in divorce, we are going to come across something called the decree nisi. That when court looks at your petition, at all the evidence you are provided, and they say, okay, these people, their marriage maybe is irreconcilable. So what they do, they give you a decree nisi for 6 months to see if you can come back, because courts do not want people to break up. Divorce is the last option. So a decree nisi is given to you for 6 months to ensure that you can make up your differences. The moment you institute conjugal rights, then that divorce will not be given out. So that is what we mean by collusion. People collide, married couples, fabricate evidence with the intention of luring court into giving them a divorce. There are many cases. I want to urge you to read cases such that you can appreciate. I can give you a list of cases. Let's look at Brain versus Brain. Brain is BRINE versus Brain. Then we have Barlow versus Barlow. Barlow, BARLOW. Barlow versus Barlow. Then we have Patel versus Patel, Indian case. Patel versus Patel, PATEL, VPATEL, Patel versus Patel. And then we have Churchward versus Churchward. Churchward actually draws us Churchward versus Churchward. It gives us a clear meaning of what collusion means in that case. So kindly read those cases and appreciate them. Brain, Brain, Barlow versus Barlow, Patel, Patel, and then Churchward versus Churchward. So let's now cross to the other one, which is condonation. Condonation. What do we mean by condonation? Now, under condonation, we mean that one of the spouses forgives the other spouse for a marital offense which has been committed. Let's take an example. My wife commits adultery, I find out, I forgive her. I have condoned. I forgive her, but it doesn't stop there. You forgive her and you reinstate your relationship. You found her red-handed, having sexual intercourse with another man, but now you forgive her and you even reinstate your relationship. You start to stay together, you reinstate conjugal rights, socializing, you stay under the same household. That way, you have condoned. You cannot now turn again and you say you want to get a divorce. Courts will not give you that divorce. I want to repeat this. Under condonation, you condone one spouse. I've given an example. You forgive your spouse for a marital offense committed. Because they have committed a marital offense, you forgive them. And it is not enough. When you forgive them, you reinstate your relationship. You continue to stay together under the same roof. You continue to be together. You reinstate conjugal rights. It means you forgive that person. You cannot turn around again and you come and apply in court that there is a divorce because in a certain month my wife cheated and I found out. For as long as you forgave her and you reinstated the earlier relationship with her, then that one literally means that you have condoned and we shall not award you a divorce. We shall not award you a divorce. Because you condoned. So, but colleagues, forgiveness alone does not work. You must reinstate. Among the elements of condonation, you forgive, you reinstate the status quo. The moment you reinstate the status quo, then you cannot turn around again and say, we want a divorce. Courts will not allow. That is what we mean by bars to divorce. There are many cases. Like I said, if you want to appreciate these concepts, read as many cases as you can, such that the cases will give you another feel. There are very many things in those cases that you must appreciate to be able to understand some of those concepts. I want to give you some of the cases under condonation. We have Mugonya versus Mugonya. Make sure you read the case of Mugonya versus Mugonya. Mugonya. Mugonya v. Mugonya. Then we have Cramp versus Cramp. Very important case. Cramp versus Cramp. And then we have Crocker versus Crocker. Crocker is Crocker versus Crocker. Crocker. So read those three cases and very many other cases, and you appreciate the concept of condonation as a bar to divorce, under absolute bars to divorce. Let's look at connivance as the last under absolute bars. Let's look at connivance. Now, under connivance, one party gives green light to the other parties, and then, but with a corrupt mind. I'll explain. This one, I won't waste time. I will use Godfrey versus Godfrey and Wall. This is locus classicus for connivance. Now, this woman, Mrs. Godfrey, told the husband, I have a friend called Wall. He would love to come here and, we be together. So the husband allowed Wall to come. So when the husband came back that evening, of course, I think he was drunk, he found Wall and the wife cozy in the sitting room, like they are all over each other. And then he told them, the two of you, why don't you go and enjoy yourself and have sex, and you have enjoy yourself in the bedroom? So the wife asked, are you sure? You sure about this? Here you go. Go and have fun. So the wife goes with Wall and they do whatever they did. Now, in the morning, the husband wants to file a divorce, claiming that you cheated on me. Courts denied it. You connived. You made these people to believe. You made your spouse to believe that you have given a go ahead, yet you wanted to get ways of running out of marriage. Marriage is sacred. Marriage is holy. You don't just run away from marriage. So connivance becomes one of the bars to divorce, that the other party gives green light to the performance of, let's say, a matrimonial offense, but with a corrupt mind of seeking for a divorce. Meaning that this person was just lying to you. Go and do it so that they can get a divorce. So there, courts will not agree with you. So read well the case of Godfrey versus Godfrey and the Wall, and also appreciate the cases of Gibbs versus Gibbs, that is GIPPS versus Gibbs, and then the case of Maddock versus Maddock, that is MADDCOK, Maddock, and then we have Douglas versus Douglas, then we have Churchman versus Churchman, and then Gibbs, Godfrey and Wall, Locus Cascas, Churchman, Douglas, Mannings versus Mannings. Manning is MANNING. Appreciate those cases, and then you'll be able to answer questions on absolute bars to divorce. So let's now go to discretionary bars. Now, under discretionary bar, we mean that courts have the powers to either grant or not to grant, depending on the circumstance of every event. Under here, we can look at a proper arrangement for the custody of children. If in a marriage, the two couples that have come to seek for a divorce, if in their marriage, they do not, like when applying for divorce, they do not have the clear arrangement on how the children are going to be looked after, taken care of, who is going to be in custody, who is going to provide. If they are not sure, courts are at liberty not to grant that divorce or to grant it. Depends on what courts do. But of course, when you come to second semester, you discuss the welfare of the best interest of the child. It is paramount consideration when handling matters of children. So when you get to second semester, you'll appreciate this concept more, that courts will depend on the best interest of the child. So where the custody of the child is not clear, courts may be hesitant to award the divorce, where they sense that the custody of child is well or good under both parties in the same household, then divorce. So that it is discretionary. Those are some of the areas where courts can be convinced to accept or not to accept, discretion of court. Then the other one is delay, unreasonable delay, time. That somebody, there are cases, I think there is one of Bini versus Bini. I can't remember, but there is a case where somebody spent 20 years in a marriage with all the atrocities committed in there. But again, after they want to move out and go and ask for divorce, court said, no, you have condoned this for so many times. You have been there for so many years. Okay? So, time. Court, under where there is delay of time, you delay to do something, court is at liberty to send away or to grant. Let me give you an example. When a decree nasi has been granted, it is normal for 6 months. But if you take long to come back to apply for the decree for the absolute, courts can deny. Unreasonable delay of time, that it is at the court's discretion, and then conducing and very many others. So we thank you so much for watching Voices of the Bar, where the legal world speaks. We thank you so much. Subscribe, share, like our videos. Like we said, we run 2 channels, Law School Made Easy and Voices of the Bar. Subscribe on both channels. Until next time, thank you so much. Cheers.